on the trigger from a distance and fire the gun. That's how it worked. It wasn't very safe. But the Liberator got better and better and eventually became a safe enough gun if you made it the right way. In fact, it's actually fairly complicated. It's not just point, click, shoot. You have to actually treat the plastic with this acetone bath to strengthen the plastic so it can handle the combustion of the firearm. Okay? Now, is there a problem? Is there anything illegal about printing your own firearm? I'm going to exclude New Jersey for the moment. You'll find out later why today. But in most states, there's nothing wrong with 3D printing a firearm. So people have in mind this, right? No, this is not how it works, right? You don't just press a button and a fully functional firearm pops out. It's actually, surprisingly, very easy to make your own gun. Very easy. For centuries, there's something called a zip gun. A zip gun is a gun you can make on your own from parts you can buy in any store. If I go to the closest hardware store and I buy $20 worth of parts, I can make a gun. You don't believe me? Look at this. This is a garden hose and a soldering iron combined, right? You take a common garden hose and you connect it to a soldering iron, and you've made a gun. That's all you need. Let me tell you something. This is a lot cheaper than a 3D printed gun. It's a lot safer than a 3D printed gun. It's a lot more effective because it's made of metal and it's not made out of plastic. I found these blueprints online. This might look like a keychain flashlight. You can make a keychain in the back, right? To make one of these. This is a keychain flashlight that's actually a gun. Looks just like a keychain, doesn't it? Now, I want to show you a demonstration of how easy it is to make a gun. Please do not try this at home. These guys are morons. Please don't try this at home. What I want to show you is how easy it is to make an undetectable firearm. Okay? They're making a rifle out of a piece of rubber tubing. Rubber is not metal. And indeed, rubber is a lot more durable than is plastic, right? They're going to make a gun out of a single piece of rubber tubing with a single shotgun shell, which doesn't have very much metal in it, and a pipe, which you can buy anywhere. So here's the idea. At the end of this pipe is a metal dimple. And what they're going to do is they're going to jam the shotgun shell into the rubber tube, okay? And they're going to thrust the metal pipe into the back of the shotgun shell. Everyone understand what's going on? Now, what's wrong with this picture? Just look at this picture for a second. What's wrong with this picture? Say it. Yeah. Say it out. Say it. What's wrong with this picture? Yeah, so his hand's covering the book. That's problem number one. Okay, I like having 10 fingers like the next guy, but that's problematic, right? What else is wrong with this picture? This isn't very obvious. Yeah, let me go one more picture forward. Everyone see it now? They're firing where there's an electrical wire plugged into a fan. Right, so my point here again is don't try this at home, but don't tell Attorney General Graywall it's very easy to make your own guns at home. Okay? So he's going to fire it. Ready? 1, 2, boom. Lethal weapon, right? He made a gun. He fired into this box. You can see there's several holes. They've done this before, obviously. And he made a gun. Totally undetectable, piece of rubber. It's really easy to make a gun, right? Look at these guys all proud. They're showing off with their shotgun shells being all smoky. The moral panic and hysteria about 3D printed guns is based on large fact that people don't know how guns work and how easy it is to make one. If you understand how easy it is to make a gun, 3D printed guns are not on your radar things to panic about and pass laws banning them. But here we are. So again, is there anything illegal, at least under federal law, about making your own firearm? The answer is no. Under ATF regulations, alcohol, tobacco, and firearms, it is perfectly lawful to make your own firearm at home so long as you don't sell it. Now, there are limitations. You can't have a sawed-off shotgun. You can't have a machine gun. But generally, if you make a gun at home and you're not selling it, it's not interstate commerce, you're fine. So then why am I here, right? Why am I even talking about this? Why am I litigating this case now for the last 3 years and going on? Because the government's not tried to only ban 3D printed guns. They've tried to take it one step forward. They've tried to prohibit us, and by say us, I actually represent Defense Distributed, the company makes these. They've tried to prohibit Defense Distributed from putting the files used to make these guns on the internet. This is not only about the possession or creation of the guns, it's about sharing the information used to make them. And that directly implicates the First Amendment of our Constitution. The basic principle of our First Amendment is that the government cannot censor speech based on its content, right? That's what's called a prior restraint of speech, right? When the government restricts speech on the basis of its content, such as a file describes how to make a gun, that is not protected speech. I'm sorry, that is protected speech. Now you might say, wait a minute, Josh, but this is not just any speech, right? You're talking about information that's dangerous, right? People download these files, they can make guns, and people download guns, there can be violence, and all these awful things can happen. Fair enough. But there's a fairly well-developed body of case law on this, where even though speech can be used to commit crimes and the like, the government needs more than that possible threat to ban information. And one of the leading examples is the Anarchist Cookbook, right? Anyone ever know about this book? A couple of you, yeah? This is basically a hand guide of how to be a terrorist. It tells you how to make bombs, how to make poison, how to kidnap people, with very detailed instructions. So we have a long history of saying we protect speech even though it can be used for danger. You say, wait a minute, Josh, this is not about a book, right? This is not banning a book. This is instead banning code. Well, my friends, information is speech. And the courts have been fairly consistent with this approach. A case called Sorrell v. IMS Health, Supreme Court decision from 2011. The creation and dissemination of information are speech within the meaning of the First Amendment. It doesn't matter if you write a violent novel or create a violent video game. The Supreme Court has held that both expressions are entitled to the same level of First Amendment scrutiny. And the mere fact that you have information in 3D blueprints and in CAD files and the like, they still have expressive value. Most of the people who have downloaded these files never printed the gun. They did it to learn, to study, maybe modifying the files, tweaking them. Okay? So that's the First Amendment angle. But I promise you 2 constitutional rights. And we also have the Second Amendment angle. The Second Amendment to our Constitution provides that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court had a leading case on the Second Amendment in 2008 in a case called District of Columbia versus Heller. And the court held that the Second Amendment protected to keep and bear arms, separate from militia service. And 2 years later, the court held that the right to keep and bear arms protects states as well, not just the federal government, in a case called McDonald v. City of Chicago. Those are the 2 leading Supreme Court cases, Heller and McDonald. This is actually Dick Heller and Otis McDonald. I love this picture. But the court hasn't seen fit to expand on the Second Amendment at all since 2010. That may change in the very near future. But to date, they haven't expanded. So I want to submit 2 arguments which are not supported in case law yet, but I do think make sense. And the first is that the Second Amendment protects a right to acquire arms. Right? Why? Imagine the government passed law saying that anyone who has a gun can keep them, but you can't buy any new guns, right? You can't buy any new ones. A functional ban on acquiring firearms, I think, would be unconstitutional. Right? You have to be able to get the gun to actually exercise your right. Now, that doesn't mean the government can't restrict who buys a gun. I'm not arguing that at all. but any law restricting access to firearms and acquiring them triggers Second Amendment scrutiny, whatever that scrutiny is. But beyond the right to acquire arms, there's another right that I think is far more basic, which is a right to make arms. Long before we had gun stores, which I know don't exist in New York, but they do exist elsewhere, trust me, they do. But long before we had gun stores, if someone wanted a gun, they'd have to make it themselves. We have a very long tradition in America of people making their own arms, especially in times of war. For example, during the American Revolution, the patriots made their own muskets. And to this day, federal law still permits you to make your own firearms. This is a deeply rooted, long-standing tradition of firearm manufacture. Okay? Again, I am not saying that there are no limits on what kind of gun you can make yourself, but still it's protected by the Second Amendment, and any law restricting that triggers the Second Amendment. Why is this important? In constitutional law, there's a concept of hybrid rights. So let's say the government passes a law that says it's a crime to wish someone a Merry Christmas, an actual war on Christmas, right? It's a crime to say Merry Christmas. Would that law violate the freedom of speech? Would it violate the freedom of exercise? Or would it violate both? There are some times where rights reinforce each other. And you can imagine, I don't know, a law banning sharing information of how to perform an abortion, to use another radical example, right? When you have free speech reinforcing other right, they work together as a hybrid right. So here what's going on is that the government's censoring people from sharing information of how to exercise your Second Amendment rights. So it's the First Amendment and the Second Amendment, and it's also the First Amendment plus Second Amendment, which is not equal to the Third Amendment, but you got two amendments there that are very, I think, important. Okay, that's the constitutional argument. Let's talk for a minute about what law exists today. So we do have a law in the books called the Undetectable Firearms Act. Okay? This law was passed in 1988. And it says that all guns must have a certain quantity of metal in them so they trigger a metal detector. Wait a minute, Josh. 1988? Wasn't the first 3D gun printed in 2013? Surprise, folks. Undetectable guns have been around for a long time, right? Making a plastic gun is not new. Perhaps making them in a printer is new, but the idea of having a plastic firearm is not novel. Indeed, much of the panic, I call it a panic, over the original undetected guns came from the Glock handgun. The Glock is a very popular handgun that was made even more popular by Bruce Willis in the Die Hard movie. And there was one scene in the movie where he reads this one line. Let me read it to you. He says, "Luggage, that punk pulled the Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up on your airport X-ray machines here, and it costs more than what you make in a month." Every aspect of that sentence is false. Every aspect, right? There is no Glock 7. It's not made of porcelain. It's made out of metal. It's not made in Germany. It's made in Austria. It will show up in an X-ray machine, and they're fairly affordable. But you know, Congress reacts to movies. That's what they legislate based on. And Congress passed this bill in the 1980s. It's still in the books today. Much today, legislatures in Trenton and elsewhere pass laws that are absolute panic based on hysteria, and then we have to go to court to deal with it. Okay, so what's going to happen? Perhaps Congress, state, New Jersey, might try to ban 3D guns. Senator Schumer likes banning stuff. He tried to ban our things. He didn't succeed. But you know, maybe Congress can ban 3D guns. So far, that hasn't actually happened, but it might happen real soon. Maybe we can ban the materials, right? If there's such a threat from 3D printed guns, maybe we can ban plastic, that people can't 3D print plastic. Actually, a law professor proposed this as a proposal. Okay? Guess what, guys? You can 3D print metal. Like Terminator, right? You can 3D print a metal firearm. That's perfect. Now, why would you do this? This costs almost $50,000. It's not a good use of money. It's expensive. You can buy a cheaper gun. It's about 5 blocks that way for maybe $100. But you don't need to do that. Okay? You can 3D print metal. So the bottom line is actually banning the end product might pose problematic. So to date, the government's tried to stop 3D printed guns through export control laws. What? There's something called ITAR, which you probably have never heard of, called the International Traffic in Arms Regulation. This is a series of statutes and laws that were largely enacted during the Cold War. And the purpose of these laws is to prevent, as the name suggests, shipping dangerous arms to foreign countries. So you can imagine, right? Sending Stinger missiles to Afghanistan, bad idea, right? Sharing the classified blueprints for a nuclear submarine with the Russians, probably a bad idea. But what's it with us? Well, the Obama administration in 2013 took the position that putting a file on the internet was an export. That sharing a file on the internet was an export because non-US persons have access to the internet, which they do, and then non-US persons would then be able to download those files and do with it as they please. So in 2013, the State Department sent a letter to Defense Distributed, who I represent. I've represented them now for nearly 4 or 5 years at this point. And they demanded that they take down the files for the Liberator and otherwise, right? They said, you need to take down the files immediately. That triggered a long litigation process, which I'll briefly explain. We filed suit in the Western District of Texas seeking a preliminary injunction back in 2015. It was denied. We appealed to the Fifth Circuit. We lost in a divided decision, 2-to-1 panel. We then sought rehearing en banc on the Fifth Circuit. We missed it by about 2 or 3 votes. We petitioned for certiorari, and the Supreme Court turned away our case. Then we went back to the trial court, the district court. And then we have what's called summary judgment. At that point, I think the government recognized that they were on very weak ground, that imposing this prior restraint was unconstitutional, and the government settled with us. At least they tried to. They agreed to let Defense Distributed and all Americans post these sorts of files to the internet. They admitted they did not want to stop that. Then comes the fun part. On the eve of the settlement, about 2 days before, there's a motion to intervene from the gun control groups, Brady, Gifford, Everytown. They sued in federal court in Texas where we were, and they argued that they had to intervene to block the settlement because putting these files on the internet would be too dangerous. So I had my first temporary restraining order argument. I argued it and I won. The judge denied the intervention motion and allowed our settlement to go into effect. Later that evening, we put all the files online. They were online for days. They're everywhere. You can find them in 5 seconds. They are on the internet. Indeed, all the files we put online were already online. There was nothing new, but they were in the public domain for a couple days. That was Friday night. Saturday happens. We say, this is going to be bad. And we start preparing a preemptive suit against certain attorneys generals, New Jersey and elsewhere, threatened us. Then on Sunday, we were about to file a complaint in federal court in Texas against the New Jersey Attorney General Graywall. About 20 minutes before we submit, we got sued in federal court in Pennsylvania. Attorney General Shapiro sought a temporary restraining order against us to stop us from putting the files online. I told his lawyer, excuse me, we put the files online 2 days ago. He's like, what? They're online already. You can't take a TRO. So then I had to argue in federal court my second TRO in 3 days. I did it by phone from LaGuardia Airport. I was actually at the airport. If you ever want to argue a TRO, do not do it at LaGuardia Airport. It's the worst airport in the world. They're probably worse, but at least in New York, it's the worst airport. So I'm sitting there screaming into my phone, talking about the First Amendment. And I tell the judge, like, look, judge, listen, here's what we're going to do. We can just block Pennsylvania IP addresses from accessing these files for the time being until we get a more suitable briefing schedule. I had no briefing. And the judge said, fine. He denied the TRO, and we blocked all Pennsylvania IP addresses, right? We actually called it our blue wall, right? Or the blue wave. This is our blue wall. We're basically blocking off the state of Pennsylvania from the internet. That had never been done before. Like, only North Korea does stuff like this. We actually figured out how to do it pretty quickly. Shortly thereafter, we were sued in state court in New Jersey. The New Jersey Attorney General sought a nationwide injunction against us in New Jersey Chancery Court. This is a court of limited jurisdiction that handles, like, small disputes of a very small quantity. So on basically 1 day's notice, I had to argue my third TRO in New Jersey Chancery Court. By the way, briefing all this up overnight. I had the argument by phone. It was not the best connection. I was home back in Houston by this point. I told the judge, like, Judge, Your Honor, there's a big controversy now over nationwide injunctions, over a federal courts can issue a nationwide injunction. With respect, Your Honor, I don't think a chancery court in New Jersey can issue a nationwide injunction against the internet. The judge's like, you might be right. So I told the judge, look, deny the TRO, here's what I'm going to do. We're going to block all New Jersey IP addresses, so basically add New Jersey to our blue wall. And the judge's like, fine, so we deny the TRO. Not done yet. So that was 3 TROs in 4 days, okay? We got one more. We were sued by the Washington Attorney General and about a dozen other states in federal court in Seattle. They sued not only us, they also sued the State Department. And they sought a TRO, a nationwide temporary restraining order, to block us from putting these files online. They've been online for days. And they sought a TRO so the government cannot honor our settlement. I argued that one by phone. Again, I was not much sleep. I had billed 90 hours in 5 days. So I argued this TRO, and there was a sign. The judge asked me only one question. He said, do you represent all the parties that are defendants? Once you get that question, you know how the case is coming out. And the answer is I did. And at the end of a hearing, he ruled from the bench and entered a nationwide temporary restraining order that blocked our settlement. And as a result, we could not share these files online. At that point, I had to call my client and say, you need to take the files down. They've been online for days, downloaded thousands and thousands of times. We took the files down. That case is still currently going through the pipeline. We've actually proactively sued the attorneys generals of New Jersey, of Pennsylvania, of Delaware. I sued Governor Cuomo too, sued the entire bunch, right? Funny story, this is actually, you're in New York, you'll appreciate this. So about 30 minutes after the judge in Seattle enters a nationwide injunction, my phone rings. I'm like, oh, who the hell is it? I'm tired, right? And it says restrict, I'm like, uh-oh. So I answer the phone, and he says, this is Governor Cuomo. I'm like, what? He's like, this is Governor Cuomo. I was like, hi, Governor. He's like, I want you to tell your client to take those files down. I'm like, Governor, your attorney general sued us for TRO and just prevailed in federal court. And he's like, what? He had no idea he just won. So he's demanding they take down files already taken down. And like, your AG sued us. And then he goes on this rant, which is pretty funny. He says, well, you know what? My AG doesn't work for me. I didn't appoint her. And starts telling me how it's complicated in New York. People don't work for him. And then we talked for 20 minutes, and I said, I'm from Staten Island. He's like, you're a Republican from Staten Island? Yeah, they exist. And then I even said, my parents, it's their anniversary today. And he said, you know what? Tell your parents Governor Cuomo said happy anniversary. And I called my parents afterwards. It was a cordial enough phone call after the threat. But once the threat was over, he was very, very cordial. I can see why he won 80% of the vote here, I suppose. But the bottom line is, this is a live issue, okay? If a state were to actually try to draft a narrowly tailored statute that tried to permit 3D printing files in a specific format, that might pass muster. I'm not going to opine on that. But under the current laws in effect now, they can't do what they've done. New Jersey sued us for a nuisance. That was their argument. That putting a file on the internet was a common law nuisance. Give me a freaking break, right? Pennsylvania sued us in federal court for violating state law. There was no federal question. Give me a break, right? So this entire litigation has been something of a mess. I think ultimately it'll be cleaned up by the Fifth Circuit, hopefully soon enough. But it's been a worthwhile experience. Hope we've learned a thing or two. And I'm happy to answer any of your questions. So thank you all so much. Yes, sir. Right there.
Yeah, you used the word moral panic to describe the kind of outcome stuff. I'm curious how the roundup and how much you did in order to get a spree in Northern California may have affected your consideration whether this is a small panic. For those of you who are familiar with the spree shooting in Northern California committed with a CNC mill, I think, not a screen printer, unregistered gun, homemade AR.
Well, thank you for the question. The reason why I use moral panic has to do with the fact that these guns are fairly expensive and difficult to obtain. People who want a more effective gun can make one themselves. The CNC mill you described is a fairly old technology. It's been around for a very long time. And I don't think banning files is a way to stop these. If federal law starts saying that you can't manufacture on firearms, it might be a different story. But so long as federal law lets you manufacture on firearms, I think largely trying to stop the files is a mistake. Thanks for the question. Yeah, in the back. Okay, thank you for the question. So, my talk here isn't about the actual printing of them or possession. I think the state can regulate the possession of these firearms. I think the state can regulate the creation of them. Where I draw the line is when they regulate the sharing of information about the files. It's the previous step of how to get the information. That's what I think triggers First Amendment scrutiny. So again, if a state wants to ban firearms that don't have a serial number, for example, right? That's something that's been litigated. I think that's a valid argument, right? If a state wants to say that guns have to have a certain quantity of metal in them, they trigger a metal detector. I can go along with it. I think there's an argument there. But where I think the states go offline is by trying to stop you from getting the files themselves. Yeah.
Thank you for your talk and the anniversary of the
Thank you so much.
It's illegal to share instructions on how to build a nuclear weapon. I imagine it's illegal to share instructions for how to build a bazooka. Is there a line that you would draw between 3D printed guns, the plastic stuff you were talking about today, like an AK-47? I mean, or would you draw a line somewhere, like obviously south of nuclear weapons and north of 3D printed guns?
So there's a funny story about, I'll use hydrogen bomb, which is a close example. In the 70s, there was a magazine called The Progressive, right? It was basically a Jacobin magazine. And they tried to publish the blueprints of how to make a hydrogen bomb. Now, who the hell is going to make a hydrogen bomb? No one, right? But they want to just publish it for the lulz, as they would say today, right, to prove a point. And a federal court actually issued an injunction barring the publication of the H-bomb. This was classified information and the like. That decision has not stood well in the test of time, and most First Amendment scholars think that's unconstitutional, right? The government can punish you for the speech you publish after the fact, but they can't stop from publishing in the first place. And this is the Pentagon Papers case, right? You ever see the Washington Post movie last year? The New York Times tried publishing these classified papers concerning the war in Southeast Asia, right? The federal government ran to court saying, stop them from publishing these papers. Well, the papers have been published in part. They said, stop publishing the rest of them. Supreme Court said unanimously, you can't stop them from publishing. You can't have a prior restraint. If you want to punish someone who has published them, that's a different story than stopping from publishing it in the first place. Yeah.
So no prior restraint, but is there a line that you would say beyond weapons of this caliber, there should be punishments?
So I would actually go the line versus public versus private speech, and that's the line that the federal code, the Federal Register actually draws. There is a long-standing doctrine about classified information not being shared with our adversaries overseas. That's the basis of the export control law. But information in the public domain that's been committed to the public domain, I think is already out there. I think that's the line I would draw. Thank you for the question. Yes, ma'am.
You mentioned the government settlement, decided to offer a settlement because they realized there are these disputes and also
Yeah, no, it's a good question. I don't, and that's a common question I get. For decades, the Department of Justice has taken the position that the export control laws can't be applied to public speech. They had a divided opinion at the Fifth Circuit. They narrowly lost en banc, and there's a very good chance if we went back up on en banc, not in the preliminary injunction standard, but on the merits, they were going to lose. If you read the Fifth Circuit's decision, it was based simply on the fact that we're on a preliminary injunction of irreparable harm. When you go up on an appeal from a summary judgment, you don't have the irreparable harm, so there's a very good chance they would not prevail. Thank you for the question. Other questions? Yes, in the back. Mm-hmm.
The idea that, like, your average person the reality that, people think the average person has 4 years experience or anything twice makes serious for a gun. So how does that kind of relate to the notion that as the framing of the understood it, there was that Second Amendment contemplated the idea that any individual there be practical restrictions on that?
Well, sure. I mean, at the time of the founding, some people were farmers, some were merchants, some were smiths, various professions. But my point's actually a little bit more basic, that there's a right to make a gun. You don't have to make your own. Maybe you can make it for someone else. But if you have the means to, you can make your own gun. Again, does not say it can't be regulated. My point isn't that it's an unlimited right, and I'm not saying that. But when you have the First Amendment combined with the Second Amendment, it gets a little bit stronger protection. That's the only reason why I bring that in. Thank you for the question. Other questions? Going once? Going twice? Thank you all so much. I appreciate it. Thank you.